Good morning. My name is J.Speedy, and this is my week 4 discussion to psychopathy in criminal court. The essential problem being addressed is whether antisocial personality disorder should be included in the insanity defense. As the J.Speedy 2016 article describes, psychiatry is not interested in blaming or binary decision-making, but the law must attribute blame in a binary fashion. Thus, we have this balancing of psychology, biology, and justice. And we have this issue of viewing the insanity defense as a psychological construct or a legal construct. At the heart of the issue is accountability for perpetrators and free will versus mental illness. Many researchers have argued the need to rethink insanity to include personality disorders, namely psychopathy, which is in essence an extension of antisocial personality disorder. They cite emotion as the core for moral decision-making, and that comes from Gonzalez-Tapia 2017, and that moral behavior may primarily be guided by such unconscious processes. At the core of psychopathy is emotional dysregulation, or lack of emotional empathy, as well as impairments in the regions of the brain associated with emotional processing. Thus, psychopaths have a, quote, compromised capacity for rational agency, at least for moral judgment. And that's Gonzalez-Tapia 2017. Glenn and Rain, 2014, have discussed how psychopaths may be able to cognitively distinguish right from wrong, but they lack the emotions to motivate them to conform their behavior to such distinctions. Often, these researchers cite the purpose of law and the court system as integrative and intimidatory prevention. However, these researchers tend to overlook the actual safeguarding purpose of the law, separating the dangerous from society. Furthermore, researchers such as Cowett have determined that just because it is difficult for a psychopath to access emotional empathy, it does not mean they can't. And they are, quote, in touch with reality during the commission of their crimes and can control their actions rationally. For example, not murdering someone in front of a police officer, or preying on easily accessed victims, or attempting to even get rid of evidence. My opinion on the matter is personality disorders, to include antisocial personality disorder and psychopathy, should not be included as a qualifying mental disorder in the insanity defense. As I've mentioned before, Oregon has amended its insanity defense to exclude defendants who merely have a personality disorder. The reason for this, cited by legislators, were based on believing the defense would be used as a way to avoid criminal responsibility. And jurors were often confused by the battle of prosecution and defense experts arguing over such things. Furthermore, the legislature wanted to limit the devotion of state resources to persons with little chance of responding favorably to treatment for the purpose of achieving community reintegration. And that comes from Slovenko 2009. On a less politically based rationale, I'm a stronger supporter of the appreciating wrongfulness test rather than the purely volitional one. It is worth mentioning that many states adhere to the M'Naughton test, which is a combination of both. In any sense, basing insanity from a volitional perspective would open the door for pedophiles, arsonists, and other people with volitional impairments. While psychopaths, or those with personality disorders, may have volitional impairment, they are not experiencing psychosis, generally, when they commit their crimes. Otherwise, we would see a lot more of those cases with happening in front of law enforcement, for example. Ensuring a prison sentence rather than confining a defendant to the hospital limits unsupervised off-premise passes and helps safeguard our community. As a police officer, I personally worked a murder where one such defendant who was deemed guilty but insane and hospitalized rather than imprisoned was granted off-premise pass and ended up committing a murder in front of a high school. Other similar horror stories and near misses exist, such as Stephen Michael Stagner, who killed 4 people and injured 3 others in a 2001 mass shooting rampage, and deemed insane, but gets to leave the hospital grounds regularly for community excursions and camping trips, and may eventually be released back into the community. And that's Mitchell, 2015. Or even Charles Longjaw, who the Oregon State Hospital released despite his serial rape and murder pass. Longjaw went on to stab a homeless man to death just over a year later. That's Fraser, 2018. And in fact, both the Fraser and Mitchell articles go on to detail even more defendants who were released early from the hospitals that went to commit on more heinous actions. And that's because hospitals aren't concerned with the crimes that these people are committing, which is what prison is concerned with. They're concerned with rehabilitating, and achieving mental sanctity for these defendants or patients. And then finally, as Jefferson and Stifford elucidated in their 2018 article, our current science indicates that psychopaths are a heterogeneous group with regard to both affect and cognitive control. The symptoms that impact the defendant's cognitive or volitional capacities vary greatly. This means a diagnosis of psychopathy does not prove alone that a defendant is legally insane. In weighing public safety with the rights of a psychopathic criminal, imprisoning a guilty antisocial defendant rather than hospitalizing them does not seem to be such a significant departure from justice where societal protection is concerned. Thank you. As always, please see my comment for all of the references.